Number 101, International Union of Painters and Allied Trades against New York State Department of Labor. Thank you. Good afternoon, Counsel.
Good afternoon, Your Honors. May it please the Court, my name is Owen Demuth on behalf of the Appellant Department of Labor. May I please reserve 3 minutes for rebuttal?
You may, sir.
Thank you very much. Your Honors, this case is about the prevailing wage law and the Department's statutory mandate as a steward of that law to do two things.
Counsel, as a steward of that law, the language, as I understand it, from 223E, right, was pulled from federal regulations under the Davis-Bacon Act. And is there any, do you know of any authority explaining how the U.S. Department of Labor interpreted or interprets the same language? Is there anything on that?
I'm afraid that I can't provide any useful information about that, since that part, I know that it's very similar. Obviously, it's the state ones eventually became called Little Davis-Bacon Acts because they were so similar. But I can't speak to the precise wording of the federal statute. And
well, the federal statute reg, I think it is, right? It's a regulation,
Yes.
is very close, almost identical to the language that was enacted as 3E. So have you looked at how the Labor Commission, the Department of Labor in the federal level interprets nearly identical language?
No, Your Honor, because we stuck with what this court held in Monarch Electrical and what we...
So how is your interpretation consistent with Monarch, and is it a natural extension of it?
It is. Thank you, Your Honor. I think that that's exactly what it is. It's an extension of the harms that this court identified in Monarch Electrical. And again, this is, we agree with Presiding Justice Whalen that there is a slight ambiguity in the statute, to the extent that it doesn't expressly say what a bona fide program is. But we think one
Isn't that defined by how you define it? A bona fide program is something the Department of Labor approves. Doesn't that make it a bona fide program? Don't you have the authority to look at the Glazier's program or whatever program comes to you and stamp it yes or stamp it no? They say in their papers that the Department of Labor or whatever office develops the curriculum pretty much in consultation. So isn't a bona fide program what you say it is?
Yes, Your Honor. I think, again, and that's giving the deference that the Fourth Department should have afforded the department.
Well, that's a little bit different. But so if you control the program, then you can control what is legitimately falls within work in that curriculum. So I don't understand what that ambiguity would be. As long as they're working within a curriculum that you've approved as an apprentice program, why don't you qualify under the statute?
Well, a little bit about that. The apprentice program called ATP in our briefs, they look at what they're concerned about is and again, these programs are generally joint sponsors, private sponsors, sometimes coalitions of unions and contractors. So what and there exists one for all of these trades. What the apprenticeship program does for the department is they try to focus on the tasks, the work processes. And that's how plaintiffs has confused this issue by referring to work processes, which are really general categories of construction.
And so just to stop, because I'm a little confused on that. So work processes may be something fairly general and have within it some other tasks. So some may be glaziers, some may be iron workers in this case?
Yes. Yeah, that's it. And again, the plaintiffs stop at the work process level, which is of no value in understanding the statute and understanding how prevailing wage trade classifications are done, because the prevailing wage trade classifications focus on the tasks. And although plaintiffs consistently argue that curtain wall, we do curtain wall in our programs, and that's really not relevant. The fact is, what are the tasks within
so let's say installation of curtain wall, right? One of the things here. So would that have tasks within it which you categorize as iron worker and as glazier?
Absolutely, Your Honor.
So I have a glazier apprentice who's doing that. So for the things within that process that you would characterize as iron worker, then he's a journey worker. And then as glazier, now I'm an apprentice. So while
Yes.
I'm doing this one thing, which is installing curtain wall, for these minutes where I'm doing this process, I'm getting paid as journey worker, iron worker, but for these minutes where I'm doing glazier part of that process, I'm getting apprentice wages. And you have to keep that track of all of that.
That's right. The contractor has the duty under the labor law to
But
keep those
you
records.
have approved that process, let's stick with installation of curtain wall, as part of the curriculum for a glazier apprentice.
Okay.
That's true, right?
Yes.
Okay. So now let me ask, okay, now in this time frame within that process where I'm doing, quote, iron work, and I'm a journey worker as an iron worker, in terms of ratios, and I don't pretend to understand those completely, but in terms of ratios, now do I count as a journey worker so the employer can bring in an apprentice iron worker as a 1-to-1 ratio with me?
My understanding is you would only do it, the requirement that you pay the journey worker wages is only for the purpose of making sure you're paying according to the nature of the work performed. It doesn't affect the ratios because that would necessarily affect the safety.
So you still have to comply with the ratios that I'm still being counted as an apprentice I'm in an apprentice program, I'm doing my apprentice
Right.
curriculum, I'm counting towards the ratio that this employer has to comply, but I don't count as a journey worker for the other side. I don't understand that. I'm getting paid as a journey worker, but I'm not counting for the employer as a journey worker for ratio.
So, counsel, allow me to interrupt for a second. On the heels of that question and how intricate that question was,
Right.
what level of deference do we give to the agency?
Deference is certainly appropriate here, and the Fourth Department erred in declining to
Interpreting a
grant it.
statute, right? Not a regulation.
Yes, deference, in which case, and the reason why is because this case goes to the heart of the trade classifications of the process.
Isn't it the problem, it's the welding problem. You know, almost every profession on a construction site where you're building a large iron latticed building, somebody's going to do welding, whether it's an iron worker, whether it's a glazer, and so the question is, when they're doing that work, does that mean that they're working out of title or they're working in title and within their profession? And the question for us is, whose call is that to make? Isn't that really the core of the deference problem?
Absolutely it is, and that's why deference should have been afforded.
Are there other concerns here in terms of, are there significant cost savings to anyone by calling someone who's a glazier, an apprentice glazier doing iron workers' work? Are there significant cost savings to the construction companies, for instance?
If they were allowed, and yes, if they were allowed to continue to pay the apprentice wage rates, even if they're doing something outside of the trade that they're registered to learn, yes, there would be. And we submit that that's probably that's what's driving this entire case, because of an attempt to kind of revisit what you held in Lantry.
Counsel, this law was passed in 66 or 67 time.
2 years. It kind of
period.
took 2 years too.
Was this always the interpretation of the statute that for 50 years or whatever it is, you have always interpreted the statute to mean this?
My understanding, Your Honor, is that they've consistently had this policy for at least 35 years, since the early 80s. It's been on their website since 2001.
So can you point to anything before that that shows that they were enforcing this policy, particularly in any other apprenticeship program? Any other enforcement action or fines or anything that you can point us to that shows that the Department of Labor was interpreting this statute this way for the first 30 years it was out there? And again, we don't seem to have anything from the Department of Labor at the U.S. that they were interpreting it this way. The only case I could find suggests they don't. But what can you point to show me that when I'm deferring to your interpretation of this statute, that this has been something that you thought of for the first 30 years this thing was out there?
I am afraid I can't point to anything before the early 80s, but I'm not sure how that would render the department's interpretation irrational.
Well, you weren't interpreting it the other way before that, were you? I mean, it wasn't the way that your opponent suggested.
No, that's my understanding. But again, I think just getting right back to the statute and that the ambiguity, which is very small.
Can I just clarify that? Your position is the ambiguity is what bona fide program means?
It's also when is an apprentice working as such?
Yes,
And-
I think
and that
that's
term
really
is not
the
to be
strength
applied
of your
generically.
argument.
I'm sorry?
Yes, that strikes me as the strength of your argument. It's not bona fide program. It's will be permitted to work as such, which begs the question. do you
Working
mean
as
an
apprentice.
In
So
a
you- so-
program or an apprentice in doing the kind of work that that person is seeking to learn through the apprenticeship program?
Exactly, Your Honor. So the legislature, you don't read apprentice generically, working before the working as such phrase. You substitute, the legislature contemplated it be a particular program. So following that example, a glazier apprentice is not working as such when he's performing work classified as ironwork. An ironworker apprentice is not working as such when he's performing work classified as glazier's work, and the examples go on. So under that interpretation, which was...
Could you require that the tasks that are part of, let's see, you said there was a difference between a work process and a task. A
Yes.
task is part of a work process.
The tests are more of the granular
Okay.
level.
So here you have different tasks within one work process that are performed by different trades, right? So in the curriculum for the apprentice program for the glaziers, does it have the detailed tasks that are only pertinent to glaziers, or does it include the tasks that are pertinent to iron workers?
Your Honors, there's nothing in this record, and certainly the plaintiffs have not identified a single task that they perform within Curtain Wall that is actually classified as ironwork. Again, they stay at these general rubrics, these general categories. But even if there were, and it may be the case, Your Honor.
My question is, couldn't the Department of Labor just go in and say, you're no longer allowed to teach this in your apprentice program, end of problem?
They could do that, but that doesn't make it irrational for them also to be able to say, we want there to be a sufficient connection between the program that you're in and the trade classification you're working in, because, again, apprentices being such a vulnerable set of
Yet
this.
to do that, I think Judge Stein's point is, and it seems to me we're confusing by saying, oh, this goes back to Monarch and these other cases and defer to your classifications. There's two different types of things going on here. You can classify a task as ironworker or glazier or welder or whatever and defer to that. And there are two classifications of pay, let's say for present purposes, journey worker or apprentice. And this case seems to me to have some confusion over those two things. And you do control the rate of pay, apprentice versus journey worker, through, it seems to me reading the statute, your approval of the program. So a fair reading to me of this statute is once you approve a program for an apprenticeship, as long as, and seems a fair reading, as long as that apprentice is working within your approved program doing tasks you've approved, they get paid the apprenticeship rate.
No, Your Honor, I respectfully disagree with that interpretation. That is indeed the limiting construction that plaintiffs have offered. That's not how the Fourth Department left the statute, but they're trying to offer limiting construction. But the apprenticeship, and this is the primary policy thing I'd like to get across, the apprenticeship curricula do not determine prevailing wage trade classifications. And this is actually available, if you look on the department's website, for every apprenticeship outline, they make that clear. They're saying...
But let's say this is a plausible interpretation. Aren't we back to what the Chief Judge asked before? Deference.
Yes.
Interpretation isn't irrational and unreasonable against otherwise the obvious import of the law. We defer to you.
Absolutely. I think deference would largely dispose of this case in the department's favor. Again, making this small inferential step in the phrase apprentice working as such, which is well within the department's interpretive authority, then you have a rational basis that's not inconsistent. And again, it's only the department's interpretation that really fulfills the two fundamental goals, two of the most fundamental goals. One might be perhaps the most important, that you pay according to the nature of the work performed. The plaintiff's argument would not do that. They want to pay glazier apprentice rates for work classified as ironwork. Well, what you're essentially doing is you're trying to backdoor, you're trying an end run around the Lantry case because you're trying to reclassify them.
And
You're
what's the
saying,
other goal? You said there were two. That was one. What's the second?
Okay, the second one is they've now kind of backed off that. They're saying, okay, well, let us simply pay iron worker apprentice rates when a glazier apprentice does work classified as iron work. But not only does that offend what this court held in Monarch, this court was very clear. It actually was upholding another department construction of the statute in that it held that all workers, apprentices, all workers covered by the prevailing wage law are to be paid journey worker wages. There's really, the prevailing wage law recognizes only two types of skill levels, unless you meet the special requirements of the apprenticeship statute.
So everybody's
you could-
played as a journey worker unless they fit an exception.
That's right. So their
The
second.
default is always a journey worker pay.
Absolutely, and that's what you held in Monarch. And, Your Honor, I want to get back to what you said at the beginning. This is an extension of the harms identified by this court in Monarch. In Monarch, the concern was the sham training programs, people who weren't really apprentices. Here, we have largely, maybe perhaps not as egregious, but we have a similar problem. We have the way the Fourth Department left the statute. A means any program. A bricklayer apprentice is permitted to go out and do electrical work and still get the apprentice wage rates. And I see, but there's one reason.
It also has to do with the appropriateness of training and supervision, too, right? I mean, it's not just the wages that are being paid, but you want to make sure that the apprentices are being supervised and trained by people within their trade.
Exactly, and that offends that sentence as well, the general idea that we have these strict ratios because we want to make sure they get adequate supervision. So if you have a bricklayer apprentice, registered program, fine. He goes out, the employer says, and nobody's saying these plaintiffs are doing that, but the interpretation applied to all, and even the plaintiffs have admitted that there are bad actors out there.
Thank you, counsel.
Oh, thank you.
Counsel? Counsel, if we were to affirm, what's the consequences to all the other trades across the state?
Well, the consequence is that under Article 23, which provides which regulates, along with the regulations, regulates apprenticeship programs, there'll be, all the other apprenticeship programs across the state will be able to perform the work that's in their apprenticeship programs.
Well,
Because,
but
and if they don't, and the other consequence is, if they don't perform that work, the DOL will come and deregister their program. Certainly it has the authority and the duty to do that.
I want to make sure you're understanding the Fourth Department's holding the way I am, which is, I think, the way counsel had just explained it. That is, the Fourth Department says if you're an apprentice, you can do any kind of work, whether it's in your curriculum or not. Is that your understanding of what it held?
It is, but it's also,
And that's not the position you're not defending that, I think.
Well, I am defending it, but I also think that there's a reason why that's a rational decision. And the reason lies in Article 23 of the labor law and the regulations they're under and the requirements that are in every apprentice agreement that every apprentice has to sign and that are in the standards of apprenticeship in every apprenticeship program.
But I thought
which
it was
is-
fairly clear from your brief that your position is that as long as you're doing work in a curriculum, and I think you make this point a number of times in your brief, that curriculum is approved by the Department of Labor for the most part in some consultation with different other folks, that as long as you're doing that work, you are getting paid an apprenticeship rate.
Exactly.
I think what Judge Wilson's asking you, are you defending the interpretation of that opinion that would say you're working in an electrician, apprentice program, and you just go do some other task, and since you're an apprentice, we're going to pay you apprentice, pipe fitting. Go do some pipe fitting for me, and we're going to pay you. Are you defending that interpretation?
Well, there's really two answers to that question. Is one, looking at the plain meaning of Section 223E, that's what it says. But that's not what Article 23 says or the apprentice program regulations say. And those are what prevent this parade of horribles that the Department of Labor is worried about. They're claiming that all these apprentices from different
But
programs.
see, the way I understood this, and I've been wrong before, but the way I understood your point of view, or the core of the argument is you've got somebody who's a glazer, he's being paid apprenticeship wages to do glazer work. When he does iron worker's work, he gets paid iron worker journeyman wages, journey person wages, and he does not get paid apprentice wages. What you're saying, your position is with the Fourth Department that you could pay apprentice wages across the board, whatever position you're working in. Is that correct?
No, not exactly.
Okay,
So
then
our,
tell
you
me
know,
why
our
I'm wrong.
position is this. So under 223, there's only two requirements
Right.
for receiving apprenticeship pay on public works projects. One, you're an apprentice registered in a bona fide program.
Right.
And two, that program is registered with the Department of Labor. There is no other requirement.
Okay, but do you have to be doing, in the way you interpret it, does that apprentice have to be doing work that is included within the curriculum for the particular trade in which the worker is an apprentice?
Well, you do, but it doesn't say that under 220. It says that under Article 23.
So when I'm a glazer and I'm going out doing ironworkers work, what wage am I paid under if I'm an apprentice glazier?
Well, if you're doing, so curtain wall is classified as ironworkers work by the Department of Labor for prevailing wage purposes.
Just straightforward. Is
Yeah.
it, you get paid ironworkers wages?
You get paid ironworkers
Journey
apprentice
person.
rate.
Where does it say that?
Well, it says in 220, there are only two requirements for getting paid as an apprentice, that you're
All right.
registered in a program by the, and
And
that
isn't that
program
the
is
core,
registered in the
let me
DOL.
slow you down a second. Isn't that the core of the dispute then? The core of this dispute is that that you shouldn't be paid iron workers apprentice wages. You should be paid iron workers journeyman wages.
Well, that's the DOL's,
I understand that. I just want to know, do you agree that's the core of the dispute between the two parties? And they
Between
made
the
a
two
rule,
parties,
they made an interpretation that said apprentices, when they're working out of their specialty, out of their apprentice specialty, have to be paid like anybody else.
Well, I think, though, that to say that, they're conflating two things, and that's why I bring up Article 23. They're conflating Article 8 and Section 223E thereunder, and Article 23, which governs apprenticeship programs. In this case, yes, so they want to.
The reason I asked the question that way is I'm trying to narrow in on the focus of what the dispute is between you, respectfully. This is the reason I'm asking that is because it seems that if what I've said is the focus of the dispute, that it's a way to circumvent the prevailing wage requirement that's in the Constitution. And maybe not for everybody, but generally it would allow you to circumvent the prevailing wage requirement. So it takes on a larger significance than a pure deference question to the department. All right?
I
That's why I'm
understand.
asking.
I understand.
So you want to address that?
Well, yeah, to follow up on that, I mean, and that's the core of our argument, that there's conflating those two different articles. And here we have, we're told about this parade of horribles, which I won't get into,
But
it's in
how
the
can you
record. But
separate those two articles? I mean, isn't the whole, aren't the purposes intertwined? And so if we accept your interpretation, for example, how are they going to enforce the ratio requirements? How do we, if somebody's getting paid as an iron worker apprentice, but they're there as a glazier apprentice, how do they count ratio-wise, for one thing, and how does it further the whole purposes of the apprenticeship program that they be appropriately supervised and that they get the appropriate training in their trade? The two things, I don't see how you can separate them.
Well, I don't think you can separate them, but I don't think they are separate. I think that's irrelevant to what the DOL is saying. Because if you look at 223E, there's a provision, I believe it's a second sentence, that discusses ratios and talks about how you're limited to the ratios that are in your registered program. So that addresses the ratio issue. Whenever an apprentice is performing work, it's the ratio in your program. Two,
So when they're
you don't
doing,
need.
I'm sorry, so when they're doing iron worker work, let's say under your theory, and they're getting paid as an iron worker apprentice, what would the applicable ratio be? How would they count?
I think the ratio would be the glazier program that they're in. They're indentured in the glazier program.
So you would maintain the same ratio?
You would.
Even though I think iron workers, if I understand this correctly, has a different ratio than the
I think so,
glazier?
slightly different. You'd maintain that ratio.
So
But
if that glazier apprentice was doing 90% of the work that worker was doing on the project was actually in the iron worker category and getting paid as an iron worker apprentice, the ratio would still count for the glazier count?
Because that's the program they're in. And I mean, this
Well,
kind of gets back,
Then what is its meaning?
well, this gets back to, you asked some questions of the DOL, Council for DOL, concerning concerning this very issue and the ratios. And he wants to say that, the DOL wants to say that there are certain tasks that fall under work processes. But that's not what the curricula that are approved by the DOL say. They say curtain wall, they say storefronts, they say pre-glazed windows.
Well,
So
doesn't that
this-
also apply to private contracts? That curriculum?
Well, actually,
To which the prevailing wage laws don't apply?
well, it would, yes.
Okay, so couldn't that have some purpose and meaning to that extent, but not be allowable in the context of public works?
I mean, I don't think so. I don't see any distinction there.
Well, let's say we agreed with you on that one. Why, I'm not really clear of this whole argument about the curriculum. What prohibits DOL from approving a curriculum that goes beyond whatever are the tasks, the nature of the work that they've approved and recognized as falling within, let's take this example, the glazier?
Well, I don't think anything prohibits them. and
Why
the
can't they do that? But yet they've identified what are the tasks that a glazier does.
I think this is, in another way, goes to the core of our argument and the dispute, is that nothing's stopping them from doing it. In fact, the record is replete with examples of how.
Yes, but you say the consequences of that are that then that apprentice can be paid less than a journeyman, a journey worker.
Right,
As long
because
as they're
he's
doing
performing.
something other than, for purposes of this hypothetical, a glazier.
Right, because he or she is performing tasks that are included in the apprentice program curriculum.
But that's what I'm saying. You're assuming that the apprentice program is reflecting only tasks that only a glazier does. No one else does those tasks. And I don't think.
No, I'm not
I don't
presuming
think
that.
they've ever said anything like that.
No, I'm
They've
not
never taken
presuming
that
that.
position about the programs.
I'm sorry, Judge.
Yeah.
All I'm saying is that those were
But
processes.
how can that not be the consequence of your argument?
Well, those work processes are included in the curricula, and those curricula are developed in consultation and approved by the Department of Labor. So, I mean, the reality of this is that this work is done. I mean, when curtain wall is put up, it's one.
Yes, but your position really boils down to the curriculum should trump whatever they have classified as the nature of work for a particular trade or a particular category. And we've already said they get to decide that.
Well, I'm not saying it should trump it. And that's, I mean, look, there's all this talk about Lantry. Lantry is, DOL brought up Lantry. We've said from the very beginning of this, we're not challenging Lantry. What the DOL is doing when it classifies the work is determining what wage gets paid for the work, what the rate is. We haven't once during this whole proceeding from Supreme Court up till now asked to be paid glazier rates. Actually, this was stated earlier. We're never asked to be
Isn't
paid
the curriculum,
glazier apprentice
counsel,
rates.
the
We said we'll pay
approval-
the posted
The
rate.
approval of curriculum to me seems like the DOL in consultation with whomever is saying you need to have training in these tasks in order to qualify as a journey worker glazier, right? This is a 4-year or whatever it is program, and it's pretty much broken down into hours and tasks and processes, and you need training in these things to qualify as a glazier and then get this glazier journey worker rate. That's how I read the curriculum. But I'd like to go back to a question I asked counsel for the Department of Labor. Are you aware of when did you become aware, or you could point to something, when the Department of Labor interpreted this statute in the way they interpret it now? Is this consistently their interpretation from 1967?
I don't believe so. I think the earliest is in the record. There's a letter, I think it's a 2005 letter from
I
Alon.
saw that letter.
That would be the earliest that I'm aware of.
Can you point to anything out there that shows they had a different interpretation prior to that?
I can't point to anything, no.
Are you aware of how the Federal Department of Labor interprets their analogous regulation?
I'm not.
Thank you, counsel. Counsel?
Very quickly, on the point of why the curricula and the morass of different things that they contain are not relevant and do not determine the prevailing wage classifications, Judge Stein, you're correct. We need to understand the context in which and the very different purposes that the apprenticeship programs serve as opposed to the prevailing wage classifications that apply only on public work jobs. Apprenticeship programs are necessarily going to be broader and flexible because they do understand the majority of these apprentices are going to go out and do private work, where you don't have to have work divided neatly into prevailing wage classification tasks. But that's what the department has to do when they're enforcing the prevailing wage law. So I understand there's going to be overlap. In fact, overlap is encouraged at that point. We want to train the apprentice in as many things as possible. We want them to be as well-rounded as possible. But that doesn't change the fact that when you're talking about the enforcement context, it's the tasks that control. And there is no basis from departing what this court held in Lantry that we're going to adhere to these tasks. This is what the department is required to come up with. And so a work process such as curtain wall is of no benefit in understanding a classification. You have to get into the granular level to do these classifications. Curtain wall is useful as a guideline, as a roadmap in apprenticeship curricula, but the task, when it comes to what the Bureau of Public Work does, they're looking at, okay, are you putting metal framing into that curtain wall? Then that's ironwork. But there are a number of tasks that are still done and classified as glazier work, which if they do that, there would be no problem with them getting a glazier's apprentice rates. And that's any type of glass setting, any type of pressure plate or sealant that's put in that curtain wall, that's glazier's work. So that's the reason why it simply can't work, that this limiting constructions they're asking for. Another reason why is, I think essentially that is, although they purport not to challenge Lantry, this is foreclosed by Lantry. What they're seeking, in order for you to agree with their limiting construction, you'd have to say, in addition to the other things that you're allowed to consider, the nature of the work test and the collective bargaining agreements, you now have to look at these labyrinthine curriculum and look and see if there's anything in common. And necessarily there's of course going to be things in common. That's going to be an administrative nightmare for the department to figure out. It's adding a requirement that you said in Lantry you don't need.
Counsel, I'm sorry, your light is on, but I'd like to just, again, looking, as Judge Fahey was saying, is what you agree and disagree with. It seems to me, and correct me please, you agree with your opponent in terms of the ratios that apply here. So a glazier in an apprentice program, no matter what that glazier apprentice is doing, has to comply with the glazier apprentice ratios.
That's my understanding. That was never briefed or discussed. That was never part of any of the 3 years that this litigation has been ongoing. But I think
that you would agree with that,
right? And there, I think actually I need to.
So neither interpretation then is really going to affect how many journey workers are there at certain tasks or how many apprentices are there. You agree on that?
I don't think it would. But I'd like to explain that second sentence, and it doesn't help their argument at all. There is a kind of an historical antiquity in that argument, in that sentence, where it talks about the ratio can't be greater than. That actually reflects back to a time when there were different, for each trade, there were different, and we've explained this in our brief, that there were different ratios for each trade. Actually, in 1995, it was the department amended it to now require statewide.
So there were different ratios in each part of the state.
Right, and that sentence still reflects that.
That sentence is lifted from the federal regulation, so it's hard to see how it was an anachronism from the state.
Well, that's my understanding of what that harkens back to, that it supports the idea that they had different ratios. But because that's changed, it's kind of outdated in that sense. It doesn't support the plaintiff's argument at all that, the phrase any craft classification means that we can freely work outside so long as we maintain the ratios.
Thank you, Counsel.
Can I get one more thing out, please?
Yes, you may, sir.
Thank you very much, Your Honor. There's just one overarching, again, the court's task is to afford this section the most practical, sensible construction. And I want to offer this to you. I submit it would make no sense that the legislature would, and there's no dispute as to the two requirements about being a registered apprentice in a DOL-approved program. It would make absolutely no sense for them to put those requirements in and then be utterly silent about what trade, whether the apprentice should actually be working in the trade that's the subject of the program. That vitiates those two protections. If you have a bricklayer apprentice who's registered in a DOL-approved bricklayer apprentice and then under the Fourth Department's construction and one of their constructions can then go out and do electrician's work, where's the benefit of those first two protections?
Thank you, Counsel.
Thank you.
I'm sorry,
Yes,
just
go
follow up on that. Just to go back to your administrative nightmare, though, but under your interpretation, they're doing this process, and then they're going to have to keep track anyway of, this particular thing is a glazier, and then I'm paying you for this, and then This particular, put the steel rod in here, that's ironworker work, so you're getting, so they're going to have to do that either way. They're going to have to keep track of that under your interpretation.
Well, that's the
of it.
employer's job, Your Honor. That's right, and
So
the
they
employer
have to
does that.
do that.
Right,
Even
because-
under his interpretation, though, they would have to do that because they'd have to be keeping track of what are they paying apprenticeship wages for as an ironworker or as a glazier. So you can, and I think there are blue books or something like that. So why can't you just look at that and see, okay, you had this person paying, you had this person doing this type of steel rod implementation on a window frame. It's the same distinction. It's just, what are you using it for?
Well, it's not the same, Your Honor, I submit, because when you're looking at what the employer has recorded as these tasks were done in these trades, it's understood that those were all the trade classifications. Now, if you accept their limited construction, they have to now scour these apprenticeship curricula. It's not just a matter of looking
They
at the
still
blue
have
book.
to
They have
keep
to look
track
at
of
all
what
these
they're
different
doing.
things, and some of them will overlap. How are they going to decide what happens to the classifications at that point? They get undermined, if not destroyed.
Thank you, Counsel.
Thank you very much.